Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Napasa, and I'm really happy that you have joined us. Before we start off with today's webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So, please feel free to join the discussion by commenting. And absolutely, today we are going to discuss on what can H-1B applicants expect in 2025. A lot of things are on our mind, and it's a very, very interesting topic and essential as well because I am sure employers and professionals are very much concerned about what to expect this year. So, if you are preparing for the H-1B process or are curious about the trends, shaping the US immigration policies, I don't think you would want to miss this session. So, please stay with us. And yes, you can also join us by dialing this number on the screen, and the number is 425-436-6335, and the access code is 988-888. It's a very good opportunity for you because we are going to be joined by our very, very important guest today, and she's none other than Attorney Prashanthi Reddy. So it's really great to have you, Prashanthi. Thank you so much for joining us today. How are you doing?
Hi, Nipasa. Good to be back after the break. And we have a lot more exciting news for this year. So, yeah, it's great to be back.
For sure, for sure. I hope you had a great vacation time, holiday time, and here's wishing that this year, 2025, is going to be a great one for you and your team.
Thank you. Thank you very much. And a happy new year to you and to everyone that is online as well.
Yes, I think this is our first webinar this year, so let's go with it. What can people out there who have joined us expect from today's session?
I guess we're discussing about what to expect. What is the future of really of H1Bs under the Trump administration? The reason we chose this topic is because there's a lot of news
Yeah,
on the GOP, and it seems to be an important. It has become suddenly an important point of discussion internally among the GOP, with two warring sides. Elon Musk on one side talking about H1Bs, Trump saying something, and then on the other side the more conservative think tank of Trump talking about restricting H1Bs. So it's been in the news a lot. So it would, we thought it'd be a great point for discussion.
absolutely, Prashanti. Especially with so many updates, policy changes, and administration change, everything is going to affect this. And we already had a session earlier before we ended the year about the new updates that are coming up this year. So I think this is going to be a great one. So thank you so much for joining. And I already see Rag has joined us. Rag, a very happy new year to you too. I hope this year will be great for you. And yes, please feel free to comment more if you have any questions on the topic. So let's go right in. I have this first question, Prashanthi, and it is what does the shift to a merit-based H-1B process really mean for applicants? And is it going to get harder from people, especially from the non-tech fields, to get selected under H-1B?
Yeah, I think so, because basically the H1B merit based is based on, it's based on merit. So they're not going to be talking about the traditional H1B process whereby everyone is invited as long as they, fulfill the requirements of the H1, which is basically you have to have a job in a specialty occupation. So if they are going to be removing that criteria and removing the H1 completely and putting a merit-based criteria, or changing the definition of who qualifies for a H1 and making it more merit-based by modifying it somewhat. Um, I think either way, it'll be a challenge to change it drastically, but let's presume they do. What does that mean? So the key aspects of a merit-based system would be that there'd be a point-based criteria. So merit-based system may prioritize applicants based on factors like education, skill, work experience, salary, maybe advanced degrees or specialized skills. So I think salary would definitely be a higher factor. So if you're getting a higher salary, you're more likely to get an approval under that system. Or it could be that only people who have a level 3 or level 4 wage salary would get an approval under H1 based system, and not the level 1 and level 2 would be removed completely. And we've seen that in the past where the Trump administration has tried to change the prevailing wage to make it higher to match level 3 and level 4. So employers offering higher wages may receive priority for their applications, and this could be a definite disadvantage for entry level positions or lower paying industries. Uh, so it would be more demand driven in the sense that preference might be given to applicants in high demand fields like tech, healthcare, STEM related role, based on what the labor market needs are at that time. This could obviously impact non-technical fields, reducing opportunities for fields in education, in the arts and social sciences, humanities, and these fields also have a lower salary and fewer specialized skills. So they wouldn't be prioritized as much as maybe the tech industry and the health industry. But within the tech industry also, you will see that there will be a focus on higher paying jobs. So unless there's specific provisions that balance out across all the industries, I think non-tech may find it harder to compete. But let's wait and see. We're just talking about purely speculative. If
Yeah,
it would be based completely on merit based, then what would happen? As I said,
exactly.
emphasis, on STEM fields. Historically, also tech roles dominate the H-1B program. Most of the H-1B numbers are taken up by, in the tech people are working in the tech field. Um, so a merit-based approach could amplify this, further, marginalizing the non-STEM applicants. Also, as I said, recent graduates, applicants with less experience might face more competition, especially in fields without a clear pathway to high salaries or advanced qualifications. So it depends on what the final outcome is and what it looks like if they're going towards a merit-based system. How will they do this? How will they equalize non-tech and tech fields? Will they even bother to do that? Will they only
Yes.
go based on high salaries in and not based on industry? We don't know. So all these uh, are open for speculation. Uh, but I think in general, non-tech applicants will find it maybe higher because their salaries are lower than tech industries salaries. So let's see. Any the tips for people who might get marginalized under this merit-based system? I would say they should focus on advanced degrees, um, showcase their niche skills if they have any, um, partner with employers, I guess, seek out employers who will be under that high demand industry. Uh, so these are a few things that can be done. Pursuing an advanced degree, so let's hope that it doesn't come to that. And even if they have some kind of a merit-based system, that it's a common sense based system and it does not marginalize anyone. So let's hope for the best.
Yes.
Only time will tell.
So true, Prashanti. And I mean, it's almost 30 years that you have been practicing immigration law, and imagine like no more lottery system for H1B. It's going to be so different, and I can only imagine. So we'll just have to wait and watch. But folks
Right.
out there, be prepared, and why not? I mean, you should always showcase your best side. And now the competition is not just the world, but also you to be the best at what you are doing, so that you could be selected. So I think that's a good thing also. Right, Prashanti?
Yeah, we should also keep in mind that all this is speculation and it's harder done than said, right?
Yes.
So, in order for him to make these drastic changes, I don't think he'll be able to do it just through regulation, because that regulation will be then challenged in court, because that's not what the Immigration and Nationality Act says, and he has to follow the law. So he might have to go through some kind of a get congressional approval to make drastic changes, but he can definitely make changes through regulation, and that itself can have a big impact on the H-1B process, without him having to, do more drastic changes, such as, changing it completely to a merit-based system. But he can implement some elements of the merit-based system and put it into the H-1B program, by just increasing the prevailing wage. And basically, what he's saying is only high salaried people are welcomed on the H-1B program, and not entry level. And that itself is kind of tuning towards a merit-based system. And he can do that very easily. But of course, that also can be challenged in court. But let's wait and watch.
Yes, let's do that. Well, K. Vishwanathan is saying hello to both of us and hope we can post questions later. Yes, you can. Please do post. And you can also join us to ask your question, by dialing the number on the screen. And the access code is also given. So just join in, even through a call. Rag, it's been a real long time, that you've been commenting. And why not join us on call today? So yes, we would love to know you. Let's go on to our next. Prashanti, that I mean, there's a talk about stricter checks on employers who sponsor H-1B visas. So, what should both employers and employees do to stay safe? Play a safe game out there.
Right. Even as per the present, the H-1B regulations that are going to take effect very soon, even as per those new H-1B regulations, they've made, compliance into a big issue. And they're saying now FDNS visits. FDNS visits are basically audits done by FDNS officers after the approval of the H1, to make sure that the person is, the employer and the employee are following the H1B rules, or the LCA, what was said on the LCA. And they've made that compulsory. Before, it was FDNS visits. You could allow the officer into your office, or you could refuse to allow them. Of course, that could lead to a denial, but now they've made it mandatory. So if you do not allow the FDNS officer to do his job via an audit, then they can deny your case simply based on the fact of non-compliance. So they've done that. They've also, um, you know, uh, kind of streamlined the H-1B process, defined specialty occupation in a better way, so that there's no room for ambiguity. They could still be, but they've tried to kind of define things more and make them streamlined. So in order to make ensure that you can pass any audit, or you can pass the stricter checks on employers sponsoring the H-1B. If you're an employer, then you should make sure you maintain your accurate records, keep detailed documentation of the job, the salary, the qualifications. Make sure you maintain your public access file with all that information in there. Comply with the wage laws, ensure that your wage meets or exceeds the prevailing wage. In case there's an audit, that will be questioned as well. Of course, at any point of time, no matter which administration is in power, you have to avoid misrepresentation. Be transparent about the nature of the job, and avoid inflating the job title, or massaging the job responsibilities to make them, more attuned to H-1B. Uh, Sometimes you may not be in a specialty occupation, and you put in responsibilities that don't actually belong to the beneficiary in order to make it look more like a specialty occupation. Avoid doing that. But you can certainly explain your job more to explain how complex it is or why you think a H1 bachelor's degree in a specific field is required, uh, as long as you don't make up stuff. So that's avoiding misrepresentation. Regularly conduct internal audits. Proactively review your compliance and visa requirements. Get in touch with your immigration attorney. They can help you with doing auditing your company as well for DOL compliance as well as USCIS compliance, making sure your public access files are in place, making sure everyone is being paid the prevailing wage, is working at the LCA location as per the LCA location. Your HR can easily do this as well. Make sure you're aware of what a public access file is, because a lot of you'll be surprised, but a lot of H-1B employers don't know what that is. And that's the first thing that an officer would look at in an audit. Also ensure that you're paying your employees on time and you're not delaying payments more than is allowed by your state, by the DOL. Um, so these are some of the things that you can do to make sure that you're always in compliance.
So,
Well, thank you
do
so
us
much.
sorry.
Thank you so much, Prashanti, for taking that up and for the detailed explanation. And yes, we do have so many folks out there who have joined us. Please stay with us. We are going to take up your questions. K. Vishwanathan, Rajesh, Vikas, thank you so much for commenting. Rag as well. We are going to take your questions very, very soon. Rag says, wee hours here. Well, chat works better than calls. All right. Thank you so much. No worries, Rag. We are just looking forward. All right. So, moving on, Prashanti, we hear new definition about specialty occupation. So, especially starting this year, do you think that some of these jobs will not qualify as specialty jobs, or maybe they will not even fall under H1B anymore?
It's possible, though. I mean, I understand that they have redefined what in a certain to a certain extent redefined what is a specialty occupation. Um, but the definition, I don't think. I mean, it depends on how you interpret it. But I don't think the definition is um, in any way more restrictive. At least that's not what it's meant to be. They have in fact said, with reference to redefining specialty occupation, they've said um, basically that what they've said is that a bachelor's degree in many fields can be required as proof that it's a specialty occupation. It does not have to be one field, but they've said also that the fields have to be well defined, and they have to be related to the job. So if you're asking for a bachelor's degree in computer science, electronic engineering, math, physics, and that's the industry standard for your particular job. In the past, maybe USCIS would say that since it's various fields and they just would presume that it's disparate and different various fields and they're not related and they would deny it. So now USCIS is saying, as per the new regulations, that it's fine if various fields are required, are common for your job, but you have to show how those different fields are related to your job. For example, if you're saying for a systems analyst that a bachelor's degree in math is required, you have to show how that math degree is related to the position of a systems analyst, and you have to go into the transcripts and see how what is related in the math program that you did in the transcripts to your actual job. So that's what they're saying. They're asking you to be more specific, but they're allowing um, they seem to be allowing different fields as long as the fields are related. So, but of course, under the Trump administration, we have to wait and see how that affects. Under the Trump administration, it's very possible that even though the intent was something under the present administration, the Trump administration can interpret that specialty occupation field much more narrowly and restrict H1Bs further, and just based on decisions say that, oh, okay, we've got this explanation from you, but we don't agree with it, so we're denying the case. We don't think physics is anyway or math is anyway related to, position of a systems analyst. So, it's all dependent on intent. What does the present administration intend to do? And they can make use of the regulations, and there's enough scope there to interpret them in many ways to further their intent. So if they want to narrow the H1Bs in general, they can narrow it by giving decisions that have a more narrow definition of what is a specialty occupation.
Specialty occupation. Right, and they have. I think there are so many updates and new jobs coming up, especially with AI ruling over the world. I think there will be so much more additions as well. Apart from subtractions. So I think yes, Prashanti, you can.
Yeah, I mean, also Nipasa, based on his previous stance on H1Bs, previously the Trump administration has often emphasized reducing what it views as misuse of the H-1B program. Of course, this is
Right.
in their world, they think that the H-1B program is being misused, and so they're trying to clamp down on it. So they've introduced policies that uh, make the eligibility criteria stricter, and so they, narrow the definition of specialty occupation, as I said. And based on, his previous executive order, Buy America, Hire America, aimed at prioritizing U.S. workers as opposed to, non-immigrants. He has increased restrictions, um, made stricter whatever jobs that they perceive as non-critical. They've made it difficult to get H1s through those, jobs. Enhanced audits. We talked already about the higher wage requirements. He's done that. Again, redefining specialty occupation. So he's done a lot of things in the past, which shows that he is strict on H1B. But we have to see whether he will balance out that and look at what is the demand for skilled workers in the tech and the AI industries and in robotics, and try to loosen up the requirements in those areas. If he's influenced more by Elon Musk, he might do that. So let's see. We have to just wait and watch what happens.
Yes, there's still say about a dozen more days, and Trump is going to hit the office. I'm sure folks are all looking out for the 20th of January. So yes, and also we hear that the per country cap for green cards has been a hot topic, and they're going to remove the per country cap. So if this happens, how do you think it's going to impact the backlog, especially for Indian applicants out there?
Well, it hasn't been in the news as much as the H-1B program has been in the news. Per country caps, yes, Elon Musk has talked about it. Uh, and, some other people in his administration have talked about it as well. Um, and he has said, in some meetings that, he wants to make sure that students, don't have to leave, etc., etc.
Yeah.
So we don't know what will happen. We have to wait and see again. Per country caps for green cards. It'll be great if it's removed. What is the impact? I mean, a lot more people will get green cards, right? People who've been here for 20 years and been struggling to maintain their status on a H-1B visa will get the benefit of it um, by getting a green card, and they will have more flexibility in their job. They will not be stuck with one employer. They will be able to open up their own businesses because a lot of these people are highly skilled, and they have, gained those skills by working in the US for so many years. So
Mhm.
to let go of that kind of talent would be just foolishness, I think, because these are potential entrepreneurs, potential leaders, people who will create jobs for sure. Because companies, even if they're working as employees, companies who hire such people will again hire more people because they're business will expand. And also, these people could be entrepreneurs themselves and open up businesses just like Elon Musk did. He was on a H-1B program. And if he had these restrictions, then we wouldn't have had Tesla and SpaceX, right?
Yes.
So that is the potential that we're talking about with reference to the green card numbers, opening up the green card numbers.
Right, right. Yes, Prashanti, thank you so much. And you already spoke about, Trump's past stance, on H-1B. And of course, we all hear that he's going to make immigration policies even stricter and tougher. So, yes, I think there is a need for skilled workers also. So maybe if you could tell us what do you think on this also, even though industries like tech and AI are in need of skilled workers.
Are you saying what is the impact for skilled workers?
Yes, I mean, looking at Trump's previous stance, when he was on rule, and now Trump 2.0 coming in, do you think that his policies are going to get stricter and tougher?
Yeah, on the whole, I think passed on based on his previous government, what they did, um just going through that, there was a focus on Buy America, Hire America, and based on that focus, the number of denials went up by 30%. Now it's point something percent. The number of RFEs went up by 60%. Now it's some 3% or 4%. Um, and there were increased restrictions, audits, visas were getting denied. He, in fact, completely stopped any visas based, he said based on COVID, but he stopped people from coming into the country completely using some old archaic rules, laws that were in place. So Title 42. So we don't know if he intends to do that again. There was a Muslim ban. People from 7 Muslim countries were completely stopped from entering into the US. All these affected the H-1B program. He wanted to introduce higher wage thresholds, and the DOL, in fact, published a regulation for those higher wages, but luckily it didn't go through. But as per that higher wage law, which was struck down by the court for some technical reasons, if they do it right this time, the minimum wages, say for a software professional, would be 200K plus, and that would pretty much wipe out 70% of the people that are eligible to file, or more, 80% maybe, to file for a H1, because there are not many people receive a wage of 200K plus uh, in the in the IT space.
Right,
So
right.
that can, severely curtail the H1B program. I don't know whether he intends to do that again or not. Um we have to wait and see, because they are, as I said, different thoughts right now. There is one group that is for a limited H1B program and one group that is completely against the H1B program.
Right.
But even Elon Musk is for uh, encouraging higher wage people and not so much entry level. So I think on the whole, IT consulting companies are going to be
Safe.
facing trouble. IT consulting companies are going to be in trouble because no one seems to be advocating for them. Um, so let's wait and see what happens.
All right. All right.
Again, a lot of it, um, even though they want to do it, they may not be able to. They can do it to a certain extent, but they may not be able to do a whole lot. It can be what happened in the previous administration, so we can expect that may be what they can do, because more than that, then they will have the courts will get involved. Then they might have to pass new laws, in which case they might need uh, majority in both the House and the Senate, which they have right now, but they might be not all Republicans may approve of those changes. So we have to wait and see. Everything is kind of up in the air.
So true, so true. So much is being said than really happening right now. I think we just have to wait and watch. But Prashanti, I think now we should address some of our questions from the viewers. Let's not make them wait too long. So let's take up this first one from K. Vishwanathan. It's not about H1B. Let's see if you would like to take it. It's about L1 visa blanket. So he says, mine is still at a petition stage and working to close before the 17th of January as he chats now. His attorney has asked for additional cost if it gets filed after the 17th. Yes. What are the challenges and changes? He's asking.
In general, L1 blanket, if you're L1 blanket, I'm not sure why you're working with USCIS with an attorney, or maybe the L1 blanket is being filed at the consulate by the attorney. But either way, L1 blankets are usually easier to get approved than individual L1 applications. If you've submitted your documentation and you're likely to file, submit your case by January or earlier the better. You might not be affected too much by the changes because it takes time for these changes to happen. I don't think it'll happen on day one. But having said that, we are already seeing certain inquiries at the consulate level, certain denials that were not there before. We're seeing certain RFEs being sent by USCIS, which were not sent before. So even before Trump comes in, we are seeing USCIS is gearing to a more Trump-like USCIS already, because the change of administration is a few days away. So that we see that they're already becoming more restrictive, but definitely makes sense to file sooner rather than later.
Thank you so much for taking this up. K. Vishwanathan, I hope you're here. We sorry for keeping you waiting too long, but I hope that you got your answer. And let's move on to our next one. This is from Indu. Hello, ma'am. My petition is still showing actively reviewing. When can I expect the result?
I'm actually not seeing any of the comments on the side panel for some reason, but if we can
Oh,
have that, that'll be great so I can read it. But so what is the question, Tipasa? And I'm not seeing any questions scrolling on the screen either.
you don't see it? Saying, hello, ma'am. My petition is still showing actively reviewing. When can I expect the result?
And now the video has frozen. Can you see me or?
Yes, we can see you.
Okay, well,
Um,
let's just go with it then because my video is frozen from my side for some reason.
okay, but then we are perfectly very clear. I mean, there is no lag,
Okay,
nothing.
okay,
So,
okay. So let's just go with it then. So what is your question? Because I don't see the scrolling.
he says his petition is still showing actively reviewing. So he's asking when can he expect the result? This should be about his H1B status, I guess. Petition.
Actively reviewing,
I
again, it depends on whether it's premium processing or whether it's regular processing. Premium processing, usually you'll get it very soon in a week or so. If it's regular processing, it can take 3 to 4 months. So I suggest that you convert to premium processing if you haven't done so. I know it's expensive, $2,000 plus. But it's regular processing is taking about 3 to 4 months.
Okay. So, Indu, I hope you got your answer. And let's go on to our next question. This is from Rag. Rag has a question again about L2 and H4. Bundling with L1 and H1 is going away on the 18th of January. What does this mean for the first time L2 H4 applicants?
We don't know that the bundling of H4 is going away completely. Yes, it is set to, as per the court decision, it is set to lapse, but it is possible that the present administration or the future administration could renew it. So again, that is up in the air. But if they don't, then we will look at again delayed processing times for H4 and H4 EAD. It could take, if they are processing it alone, even now we are seeing that it's taking 8 to 10 months to process. During the Trump administration, we saw that the H4 and H4 EAD, though they could not or did not make any changes with reference to removing them, they delayed the processing time to such an extent that it became the benefit was completely nullified because it was taking 18 months or so for people to just get the H4 or H4 EAD, and nobody, especially if they're working, if it takes so long to get an EAD, then it nullifies the purpose, and then they cannot remain in their jobs. But now with EAD automatic extensions, that should help, even if there's a delay in processing, unless the Trump administration removes that EAD automatic extensions, then of course, then it would affect you negatively, and then you may not be able to remain on a H4 EAD because your job will not, nobody will keep the job open until you get the extension.
So true, so true. Thank you so much for taking this up, Prashanti, for Rag. And folks out there, you can join us on call. I mean, this goes to everyone, Indu, RK, Rag, the Silence Files. You can join us on this number, 425-436-6335, and the access code is 988-888. And once you're in, just speak. We will be able to hear you. This goes out to also K. Vishwanathan and everyone else who have joined us today. So my next one, let's take this one. Train me, saying, "Hi, this is Kiran. I am an H-1B holder. My I-94 is expiring on 12th of January due to my passport expiration. I have applied for my passport renewal, but I do not have a new passport yet. What should I do?"
So they're saying that the I-94 is expiring because why did they, if the I-94 is expiring, they can apply for an extension, right? But she's saying that the passport is expiring.
Yes, the I-94 is expiring on 12th Jan because of the passport expiration.
So what is the question?
So the question is, I have applied for my passport renewal, but I do not have a new passport yet. What should Kiran do?
So if you can file an extension of, I don't know on what status she is or he is, but they can file for renewal of their I-94. They have to before it expires. If they don't, then they have to leave the country, and they should be able to file without a passport, uh, and then there will be an RFE, and then it's possible maybe to submit the passport upon receiving the RFE, and then hopefully USCIS will adjudicate your case. Though USCIS might say that you don't meet the requirements as of the date of filing, if they follow that strict interpretation, then you're in trouble. But if they don't and accept your passport, uh, then it should be okay. So I would file for a country and not allow your I-94 to lapse, whether you get your passport or not.
Okay. Thank you so much for taking this up, and I hope, Kiran, you got your answer. Now, well, the silence files, I think we should take the question up. He was saying, "Can you please pick my question?" Yes, we can. So this is on your channel, Prashanti. So asking, I got 221G. Should I wait or look for transfer of H1B approved petition to new employer? And how to find new employer?
I can't help you with how to find new employer, but with reference to should I wait or not, that's up to you. But it really depends on what is the strength of the present H-1B petition that you have. And it also depends on what they're asking for in the 221G, and whether the employer is able and willing to submit those documentation. If it is a legitimate case and if they're able to submit the documentation, whatever is asked for, then I think there's no harm in waiting. But if you have, that they are asking for something which your employer is not able to provide, or will not be able to provide in a satisfactory manner, then you should definitely look for a new case. So it's important to evaluate your case and then decide. But even if it's a good case, you should know that it will take some time maybe to process it. Once it goes into 221G, it could take 6 months, 1 year. So you have to be patient and willing to wait, and it's worth it. The wait is worth it if you think you have a good case. Otherwise, you might just be better off filing another H-1B cap exempt petition, since you certainly qualify for that, at least based on the present rules.
Okay. Thank you so much for your question, the silence files, and I hope you're happy to get your answer. Thank you, Prashanti. Well, K. Vishwanathan is back, just asking one question: is L2 work permit also being withheld?
No, an L2 is something that is automatic with an L1. You don't even have to file a work permit as per the new regulations. So unless they change the regulations and make you file a L2 application, that's what it is. And there is no talk about taking away the L2. There never has been. It's always been about H4 EAD, because L2 has always has been there for many years. Uh, and no one has talked about removing it.
Okay. Thank you, Prashanti, for taking this up, and I hope you've got
And
your
I
answer.
think
Yeah.
L2 is also part of the regulation, part of the L1 regulation. So it'll be more difficult to take that away. But whereas the H4 EAD was done as an executive order, so therefore people talk about removing that because it's easier to do it.
Okay. Well, thank you. Thank you. He says he's listening and learning. Thank you so much for joining us, K. Vishwanathan. And stay with us. Maybe you could just stay up, learn more till the end. And also, now let's take up RK's question. How would the new requirements of the bona fide job offer work when filing a new H1B base of the new regulations? Also, what would be the impact on third party placement?
Right. So this is the bona fide job offer is part of the regulations. We were expecting this. This has always been something USCIS has asked for in the recent past, at least in the past 10 years. And only recently in 2020, because of the IT Serve versus Cessna decision, USCIS reserved the right to ask for bona fide employment, but did not really ask for in-client letters and purchase orders, etc. But now they have put it as part of they were waiting to put it as part of the regulation. Now that they have included it in the regulation, which can certainly be challenged in court, even though it's a regulation, but more difficult to challenge it. The bona fide job offer means that, especially in the scenario, like you said, third party placements, that is an IT consulting company scenario, it plays a big role, because in order to show that you have a job, you have to provide then the contracts and work orders that you have with your end client, because that's how third party placement works. That's how consulting companies work. They don't hire people directly, but they place them at third party sites. So they're asking for contracts, work orders, vendor letters, end client letters. They can ask for contracts between all the layers if there are 2 or 3 layers. So they can start asking for all that. And they can certainly restrict the duration of the H1 if they see that the contracts are not there for 3 years, or you're not able to show a bona fide job offer for 3 years. But they have said kind of in the regulation that they don't intend to do that, to restrict the H1B term to coincide with what's in the purchase order. But with the new administration coming in, they might do that as well. So you're looking at, you cannot file H1 speculatively anymore if you're an employer. You have to actually have a job available in order to file, which is challenging, especially for cap cases, for new cases, because you file the H1B cap cases 6 months in advance generally. And when you file that, you might have a job offer in place, but no client generally will wait for 6 months for you to get the person into the US, because jobs usually fill up faster, and usually the requirement is immediate. So if they might close out the requirement if they don't get anyone, and maybe have someone offshore work for them, have their offshore company hire someone, and that's what we're talking about, right? By restricting the H-1Bs, you are taking all the revenues offshore. So Costa Rica, Mexico, India, these countries definitely benefit, but the United States doesn't.
Yes, so true. Thank you so much, Prashanti. And RK, thank you for your question. I hope you've got your answer. And now let's go on to Esther's question. Esther saying, I got selected in the H1B lottery 2024, filed my petition around May, got a response in August, but it was an RFE on my qualification. Basically, what they were saying in the RFE was that the job that she was applying for doesn't relate with her qualifications. And my attorney advised I add an expert opinion letter to the new petition and some other documents. What do you think are my chances? She even said that she filed the RFE in October 2024, but she did not get a response yet. So what should she do and what should she expect?
What are your chances? That really depends on what your qualifications were and whether they were related or not, whether you were able to make up a case, make a case that your qualifications are related. Maybe you put an experience. Maybe you get an expert opinion letter for a work experience evaluation, or maybe you showed that the degree was related by itself by comparing your subjects that you took with the job, like a table comparing the job duties versus the subjects that you took. That's generally what is done in order to show that there's a relationship between the job and the degree. um, so it really depends on how strong your case was. If it was a strong case, then you can expect an approval. But of course, there are anomalies always. Sometimes even when you do the right thing, and you show that you're qualified, um, USCIS can deny those cases. In which case, it might be a good case for appeal. Um, but I would say just you have to wait and see, because I don't know what are the details of your case. And even if I did know, I don't know if the USCIS officer will follow the general norm of who qualifies and who doesn't, because nowadays strange things are happening. So
Yes.
I guess you have to wait and watch. If you are if you want to get a response faster, I would suggest you convert to premium processing so that you'll get a response within a week. Remember, even if it gets denied, you have 30 days to file an appeal. And once you file the appeal, it is possible to then file for a change of status to a different status, or file a transfer or whatever, um, to a different status if your I-94 is expired. If your I-94 is not expired, then you're fine. You can just, if it gets denied, then status quo is maintained, your present status is maintained, and then you can figure out what you want to do, maybe file another H-1B petition under the cap, but you are certainly will be subject to the cap again because your H-1 was not approved.
Right, right. She says thanks, and she was also saying, do the USCIS also request for tax return from the employer?
They could, but depends on the circumstances. Usually they don't.
Okay. Okay. Thank you, Esther, for joining us with your questions, and I hope you've got your answer. We also have yeah, the silence files coming back with another
I
question.
like the name.
Yeah, what's the name? I wonder. Yes, please tell us your real name. I mean, this is probably
Or
just a
what it
username.
means, what silence files means, what
The
it
silence file
signifies.
sounds so
Yeah,
mysterious, right?
very
But
mysterious.
yeah. So saying my employer has not received any email till now from the consulate, and that is a small employer with an in-house project only. The interview
Hmm.
was on the 3rd of January this year, I think. Yeah.
So that is not, I mean, hold your horses, be patient. January 3rd is not that long ago, right?
It's just
You're
5 days
expect
back.
you're expecting like, something, a response for 221G in 5 days. You have to be patient. But having said that, since it's a small employer, like you said, in-house, it doesn't seem to be a very strong case. But I wouldn't say that you have waited enough time to know that or not.
All right. Patience is virtue, and all the best. Just wait a little longer. I'm sure they will get back to you. And Muhammad Ali says, "Nice to see you here again. Nice to see you too. Thank you so much for joining us." We have some more questions from our end. I think we should take them up. Control, if you could display them, please. Uh, it'll be great. But before that, maybe we can also take Rajesh's question. Meanwhile, saying, "I've heard a lot about potential changes to the H-1B lottery system. If the rules change again in 2025, like focusing on higher wages or prioritizing certain industries, how will they impact someone like me who's applying from a mid-level tech job?"
So if you get into level three, maybe you should be okay. But if not, there might be an issue. You have to wait and see. If you are level three, maybe you're okay. We don't know. Again, because there's nothing has been defined as yet, nothing, there's no clear understanding. We just have examples of what was given last time. The way the wages were structured, they said that even anyone below 200,000, again, it depends on which state you're in, but which county you're in, but they said that 200,000 was the average salary based on the new DOL prevailing wage calculations. So then you would know whether you're in or not based on the previous wage rule. We don't know whether it'll be the same wage rule that comes in. If it even if it comes in, whether it'll be upheld by the courts or not. Previously some decisions by Trump were upheld, others were not. The Supreme Court upheld the Muslim ban, right? Though the lower courts uh, said it was unconstitutional, but many other Trump rules were not upheld by the court, such as the wage law, the H4 EAD law. So we have to wait and see what happens, really. Hard to say,
Okay,
but looks like you might be affected if it comes to the wage rule based on, what the previous rule was.
okay, okay. Thank you so much, Prashanti, for taking this up for Rajesh. Um, say,
Um,
K.
can
Vishwanathan
I?
is
Can
back.
you just give
Yeah.
me? I just need to plug in my computer. Can you give me a minute?
All right, sure.
Sure.
Sure thing. And meanwhile, folks out there, you can join us, on call as well. You can dial this number 425-436-6335, and the access code is 988-888. And once you're in, you will be able to speak with us. I mean, it's so great that you have joined us by commenting, but it'll be great to even hear you. So you might as well join us. And meanwhile,
I'm back.
folks, you can also contact our attorney, and you can have a call with her. You can even email her. Her number is 212-354-1010, and her email address is prashanti@reddyesq.com. And also go visit www.reddyesq.com to get to know more about Prashanti. And good to have you back, Prashanti. Well, let's take up some questions from our Facebook and YouTube, if since we still have about a couple of minutes. So, Control, if you could display, please.
By the way,
So this,
just to let you know, I
yeah.
can't see anything, so you'll have to read it out.
Okay, sure, Prashanti. Saying, "Hi everyone. I've been job hunting for a few months, and with my visa nearing its end, I'm considering returning to India temporarily. I'd like to get your thoughts on the current hiring trends. I am on H-1B visa with 3 years remaining. So I wouldn't need to go through the lottery process again. However, I'm curious, do employers tend to prefer local candidates over someone outside the US, even if the sponsorship process is relatively straightforward? And how easy or difficult is it to come back to the US if I leave without a job? He would like some, he or she would like some perspectives.
Right. I mean, it's a good question, and everybody's asking that question, especially with the number of layoffs in the tech industry recently. I get people at least one call a day uh, in the same subject. Um, so it's hard to say when you'll get your next job, right? But it is true that a lot of companies don't want to sponsor for a H1 because they're just not comfortable with the process. It is a process that may be straightforward, but involves paperwork and is a learning curve. So if you've never filed a H1 before for that employer, it seems like a lot of work. Uh, and there is also compliance issues. You have to pay the prevailing wage, you might get audited. So employers don't want to deal with all that. So employers who are used to it and who have done it might be willing to, but people who have not done it before might hesitate to. But the thing that you have in your favor maybe is that they may not find a US citizen or a person with a VEAD or a permanent resident uh, to fill that job. If they're not able to, then they are forced to then file a H1, which is the case in most instances where people, are first-time H1B filers, employers are first-time H1B filers. It's because they can't find anyone who's a US citizen, or it could be that they don't find a candidate that's good enough as you, that's as good as you, right? So they are willing to go through the process no matter what because you're the best candidate that they have. So that's a possibility. And what was the second part of the question?
The second part of the question was how easy or difficult is it to come back to the US if he
Yeah,
leaves without a job?
right. Then you have to find a job while you're outside the country, which is maybe difficult because most employers require you to go through an interview if
Right.
and maybe they're not comfortable with video interviews. If they are, then that's certainly a possibility, but they might want to do an in-person interview, in which case you're at a disadvantage. You could get a job with a consulting company because they don't care, but in order to get an end client or to be picked by an end client, again, they're looking for maybe in-person interviews. So if they're willing to do video interviews, again, they want you to be in the US. They don't want you to be taking the video call from India. That's also a restriction with some employers. So it depends really. Definitely, your chances are less if you're outside the country versus if you're in the country. So you might want to consider filing a change of status to student status or visitor's visa status that will give you some time to recoup, maybe find another job, improve your skills, etc., etc.
Thank you, Prashanti, for taking that up. Let's go on to our next quickly. I mean, if you still got a little time, some more time, Prashanti.
Sure, maybe one or two more questions.
This one is saying, "Hi all, I'm switching from my current employer to new employer. Please let me know odd mandate if it's odd mandatory to take the I-140 approval document from the current employer. It's a consultancy, so I'm not sure if they will give."
Yes, you would need a copy of your I-140 approval. You don't need the original. You need the copy so that you can file for your H1 beyond 6 years because you have to, if you pass the 6 years period, because you need to submit a copy of your H1B, your I-140 approval when you're filing your H1 beyond 6 years. So definitely need a copy. You don't need the original.
Okay.
And you also need a copy of the I-140 to port your priority date in case you are leaving and another employer is filing your green card. Then you should port the priority date from your previous I-140, and for that also you need a copy.
All right.
It is,
Thank you. Thank you.
having said that, it is, sorry, it is possible to get, if your employer is not giving you a copy, it's possible to get um, uh, part of the I-140, not the exact approval, but enough for you to file. When you do a FOIA case, Freedom of Information Act, under the Freedom of Information Act, they do send you a stamped I-140 petition, which can act as an approval.
Well, that's very interesting. Thank you so much, Prashanti. And maybe let's take up one last before we leave. And if you could tell us, please tell the possible outcome for scenario like a mechanical engineering graduate with 10 plus years of experience in software development.
I think you qualify because you just need to get a work experience evaluation done since you have 10 plus years experience in the IT field. You have good experience letters. Get the evaluation done before you file the H1, but you should be good.
All right. Thank you so much, Prashanti. I know there's so much more to talk about, but Shushant has joined us on YouTube asking, what about for EB3, all other countries? Well, I think we will touch up on EB3 in another episode, Shushant. But thank you so much for joining us. We have been discussing today about H1B and how does 2025 look ahead, for H1B applicants. So I'm sure there's so much more to speak about, right, Prashanti? And we would like to come back maybe with this topic or more new topics on what to expect this year since it's the beginning of the year. So, Prashanti, maybe before we leave, if you have any notes or tips for the audience out there who are really anxious to know, what's going to happen with their H1B this year.
Yeah, definitely it is. I understand why you're anxious, and we are all anxious as well for you. Uh, and the good thing is that you have the support that you need. Make sure you keep in touch with your attorney to so that you can get updates on what is happening, or if there is any situation that goes south, you can take their advice on how to proceed. So always keep abreast of the news, stay in touch with your attorney, make sure you get the proper advice. It may not affect a lot of people, but it'll affect some people. Um, and we have to just wait and watch. We can't react before we know what the process is or what is going to happen. There's no point in being anxious about what we don't know. The only thing we can do is be prepared rather than being anxious. So be prepared for uh, whatever there is to come. Have alternatives in place. Always have alternatives. So if one thing is not working out, you should be able to have an alternative that you can switch to, maybe an F1, maybe a H4 EAD. Um, you know, Maybe you go to Canada because it's not worth staying in the US anymore. uh, so there are alternatives always. So keep alternatives in mind. Don't be anxious, just be prepared.
Thank you so much. I think that's a great tip to be more prepared than just being anxious. And here's wishing that 2025 is going to be great for all of us, employers, employees, professionals, and even attorneys. So thank you so much, folks, for joining us. And K. Vishwanathan says, thank you for answering with ease, Prashanti. And my wife seems more comfortable to quit here if we succeed in this visa dream. Well, that's that's a good one, I think. So thank you so much for joining all of us, and he's wishing all of you a wonderful day ahead. Thank you so much, Prashanti, once again. And folks out there, you can also consult with attorney Prashanti. Her number is 212-354-1010, and her email address is prashanti@reddyesq.com, because that's where she will be able to get in touch with you better, know your case better. So yes, do get in touch with her. Thank you for joining once again, and have a great day ahead, everyone.
Thank you.
All right. So